Honorable, the Supreme Court.
Thank you very much. Please be seated. And please call the case.
Good morning, Your Honors. The matter before the court today is the case entitled Daniel S. Shaffer in his capacity as administrator for the estate of Jared T. Shaffer versus Northeast Kingdom Human Services Incorporated. Case number 24 AP 174. Appellant Daniel S. Shaffer is self-represented. Representing the appellee, Northeast Kingdom Human Services Incorporated, is Richard Windish. Seated at council table with Attorney Windish is Elizabeth Wilhite.
Okay, thank you very much. Mr. Shaffer, sir, you understand a little bit about the process? Come on up to the podium if you would, please, sir. So you have 15 minutes, I'm sure. I would hope, I expect this has already been explained to you. The light will go on. If you want a warning, we'll try to give you a warning before your 15 minutes is up. You're welcome to reserve, and typically the appellant reserves a minute or two of their time for rebuttal. You're entitled to rebuttal as well after the attorney for the appellee speaks. So, having said all that, we're joined this morning for your edification by students from a local high school, Mount Mansfield High School. We're pleased to have them here in the courtroom with us with their teacher. So, having said all that, please start by introducing yourself if you would, and then proceed.
Okay, good morning, Your Honors, and thank you for this opportunity for me to be here and speak directly to you.
Thank you.
And thank you for the students for watching. I hope they learned something. I'd like to speak about the 6 or 7 points that I have very quickly for about 12 minutes, and I would like to reserve 3 minutes to rebut what's coming after me.
All right.
Okay, so first of all is the comparative negligence. There's no way that comparative negligence should have been in this case. I represent Jared Shaffer, my son, who passed away at the negligence of Northeast Kingdom Services, Human Services. And I am not the one on trial, but yet the judge allowed this comparative negligence to be put in this case and turned the tables and put me on trial as the guardian. And they used the guardian as the excuse as to why my son died for comparative negligence. Why would I want that to happen? So when the counsel came up and talked about it, they kept talking about me. In fact, the judge in the notes and the original instructions to the jury said Daniel S. Shaffer versus Northeast Kingdom. And that is not true. My son is the one who's suing this organization for what happened to him. Then they used the guardian rules from New York State. Now, I don't think this judge knew the guardian rules from New York State, and I don't think the counsel did. It's section 17A. 17A is a specific section in the law in New York State for guardians' responsibilities. And they are trying to blame me that I didn't get my son's medical records and do something about it. I'm not a doctor. And 17A, paragraph SCP 1750B, which I wrote about, states that I have the ability to get the records. It doesn't say I have to get the records. So the judge left the jury trying to figure out guardianship regulations and responsibilities from New York State, and it was wide open. And even when I was asked on the stand about my guardianship, I even said to counsel, "Are you referring to 17A?" I said 17A, and he ignored it. So that's my first point. My second point is about Michael Montgomery. Michael Montgomery was the service person coordinator for my son, Jared. And he is a qualified developmental disability professional, and he was also designated as the Rule 30B6 corporate designee for Northeast Kingdom Human Services. He gets on the stand, and my counsel asks him about the master grant agreement. The master grant agreement is at the top of the pyramid of the whole structure of the Medicare, Medicaid, and developmental disabilities for people in the state of Vermont. He never read it. Claims he never read it. Now, if you're a qualified person, I'm a CPA, I'm a chartered life underwriter designation, I'm a chartered financial consultant, I'm a financial advisor. I have a lot of regulations. I have read my regulations and my responsibilities, and I follow them. And that's it. And he gets up there and says he's never read it. And I'm like, well, how can that be? Then counsel objects. Counsel objects that my attorney's asking him about the master agreement. He's a layperson. That was what was used. He's a layperson. No, he's not. He is a 30B6 corporate designee. And in that corporate designee, he was supposed to know the internal policies related to the organization. And he was supposed to know Northeast Kingdom's compliance with applicable rules and regulations. And because he didn't know that, counsel calls him a layperson. And in the regulations for this, if anything is, if in this regulation, if he's failed to adequately prepare for Rule 30B6, the deponent can be sanctioned. Now, he should have known this master agreement. Okay, let's go to the next step. Now he was questioned about the files. Dale, the disability act, or what, I forgot the exact term. Dale now does an audit of 45 cases at Northeast Kingdom, 41 of them with incomplete documents. So he starts to get asked by my counsel, was Jared one of those? Objection, Your Honor, came in. They were under audit. He was questioned about the files, and there was no foundation. The judge is giving every excuse he can to prevent this organization from being guilty. In those files, we're missing the 2014-15 medical records that he was supposed to see, or 15, whatever the years were. They weren't in there, where it said, test these down with masses. If he had only read the medical records, my son would be alive today and not be sitting in a box next to my desk. Furthermore, a reasonable jury hearing what's going on would question all of this stuff. But yet they bring in the shill, Teresa Woods, a senator.
Mr. Shaffer, listen, I appreciate
This
I appreciate you're very upset, but please, the language, a shill.
excuse me,
Yeah,
I apologize.
This is
I
not a
apologize.
forum for that kind of language.
All
We have a process here. We use respect for each other.
I'm sorry.
We engage in civil discourse.
I'm losing
This
my
is something the
losing my
student,
time.
no,
I
I won't
apologize.
take this time away from you.
I apologize.
The students need to understand this. This is a courtroom of law, and we treat each other with respect. And I have the utmost sympathy for the loss that you have suffered personally. But what we're here for is to talk about what the law is. So please refrain from using that kind of language.
I think you feel my grief.
I certainly do. Thank you. Please don't
Thank you.
take that time away from
Okay.
the appellant.
So Teresa Wood comes in and has never, as an expert witness, she's never been an expert witness before. She was never employed by a designated agency, never employed as a service coordinator. And she started arguing about the word should and shall in the language and the regulations. And the credibility of what she did, she came in, and I have them here, but I'm not going to waste time. They put up slides. They put up slides of her interpretation of why Northeast Kingdom was not liable, because the doctor got paid a certain way that didn't flow through. But yet the master agreement doesn't say that. And she misled the jury and the court of her interpretation, which was not even in her deposition. And I even mentioned in my briefs, I can't find those slides in the record. And I'm very disturbed about the way she presented that to the jury. And that is, This is supposed to be a professional who wrote the records, and she comes in. Now, how about this part? She was asked if she read the master grant agreement. No, she didn't read it either. How can that be? We have Michael Montgomery, who's a service coordinator, who's a qualified disability expert, and Teresa Woods comes in as an expert who claiming wrote regulations, and she never read the master agreement from the state of how this works. Now, I'm not a conspiracy theorist, but you have two witnesses that both didn't read the master agreement. And you have a multi-billion-dollar insurance company behind this case. I'm not dealing with Northeast Kingdom anymore. They bullied me with a letter through my attorney to try to settle this case. They're very mean people, and they concocted this case through this attorney to use the comparative negligence and to make sure that these two witnesses did not read the master agreement, and that this guy, Michael Montgomery, was considered a layman. There should be sanctions against what happened in that court, and that judge should have stopped it, because accordingly, and this court ruled on it, accordingly, the judge has the ability or the responsibility of checking the credibility of witnesses and weighing the strength of evidence. It was case law in this court, and I wrote it in my brief, and it's there. So I'm very upset about this, as you can tell, and I have every right to be upset about this. It really, I'm very educated. I have a master's degree in accounting. I went to Syracuse University undergrad. I've been a financial commentator in the media for years. I'm not anymore. I did it for many years. I wrote a book. I'm an author. My book had to be checked to make sure of its actual legal authenticity, that every fact had to be checked. And here we have two people on the stand who don't know what's going on, and they're considered lay people, and the judge says that's okay. So I'm appealing this case. And these are just the major items that occurred. I don't have enough time and enough room to write because I ran out of words in my original brief. There's just so much that went wrong. And I gave you all the transcripts. I bought all the transcripts. And this is my case. And I have probably a minute or two, and I'd be happy to answer questions, but I want to reserve 3 minutes to rebut what he's going to say.
Okay. All right. I don't see any hands, so thank you.
Is that good or bad? No hands?
I don't
Well,
know.
thank you. I really appreciate
Yep.
your time and allowing me to come up here in the dead of winter, 0 degrees, to enjoy this, and I'll be back. Thank you very much.
Thank you very much. We'll hear from counsel for the appellee now. Please come on up to the podium. And before you start, please introduce yourself, identify your client, and then proceed.
Thank you, Your Honors. My name is Richard Windish, and with me at council table is Elizabeth Wilhite. We work at Primer. We tried this case below. We're here to argue today on behalf of our client, defendant, appellee, Northeast Kingdom Human Services. And for the benefit of the students in the audience, this case involves the unfortunate death of a young man who had undiagnosed testicular cancer. And the case went to the jury against Northeast Kingdom Human Services, which provided case management services to the individual through his Medicaid waiver. After 6 days of testimony, the jury returned a verdict in favor of the defense. Dan Shaffer stands here today before you as a litigant who is disappointed and apparently very angry about the outcome of the jury trial that was decided in favor of the defense. Although he may be disappointed, disappointment alone does not form the basis for a reversal of the jury verdict.
Mr. Windish, let's
Yes.
go to the comparative negligence
I'm
of a
gonna-
non-party.
So-
Which you pled you pled comparative negligence as part of an affirmative defense against a non-party. And what authority is under Vermont's wrongful death statute or Vermont's survival statute is there to say that it should even be discussed from a non-party?
Right.
Or how do you allocate fault to somebody who's not involved in the case under Vermont law?
So Dan Shaffer was the guardian, the administrator of the estate, and the party in
He's
interest.
not a party, and he was not an individual party.
So the court addressed this in the pretrial ruling dated April 29th before the trial, where they had filed a motion to strike the affirmative defense. And the court found 2 reasons why the affirmative defense applied. First of all, based on the language of Vermont's wrongful death statute, the way that funds are distributed through the wrongful death action is it's for the benefit of the survivors and next of kin, which he was one.
Well, it's personal representative is what the law says, right?
Correct.
Personal representative. Uh, I mean, isn't our statute in this regard much more similar to the statute in New Hampshire? The judge cited the case, regarding this same issue under their law.
So the statute,
Isn't ours more similar to that?
I'm sorry, Your Honor, didn't mean to interrupt. So the statute in New Hampshire is different, and the case that was cited.
Well, it's the estate. It says the estate, but here, we say the personal representative. What is a personal representative except somebody who is either an administrator or an executor of the estate? Isn't
So-
that the same thing?
The critical difference, Your Honor,
Yeah.
is found in the language of the New Hampshire statute, which states that the damages shall become part of the decedent's estate, whereas in Vermont, the damages are for the benefit of the next of kin and distributed through the personal representative as provided in the statute. And that was the critical distinction that Judge Richardson found on that point, and that was why he allowed it to go to the jury. What he found was that the language of our statute was most similar to the states in which comparative fault was allowed. He cited CJS and a collection of cases where other states allow comparative fault in these situations.
Well, yeah, but I didn't look at every case, but I certainly looked at some of them, and I know in most of those cases, it appeared to me, the state statute actually expressly provides for the application of this rule, which is much different than what our statute does.
Right. So I would offer that it's a distinction here without a difference. In this case, comparative fault was not reached by the jury. So even
Couldn't it
if,
provide us
I don't
some
think the court
confusion?
needs to
Couldn't-
reach
couldn't-
that issue today.
Couldn't it provide us some confusion to the jury? If you're
Well-
putting in comparative fault to a non-party and they're throwing all that information at a jury who needs to make a decision?
So
And then so that isn't there a potential for confusion here?
I would offer not, Your Honor. So if that was the case, then it would be confusing to the jury every time there's a line item on the jury instructions for damages. So the jury instructions and the jury verdict form have questions, as you know, and so the jury never got to that question. The mere fact that it was there, I don't think offered any potential for
But
confusion.
isn't it prejudice where, am I right that the judge gave a copy of his charge to the jurors?
Yes.
And this is part of the appeal, of course, what I was surprised to see was that the caption of the case was Daniel Shaffer against Northeast Kingdom, not what the original caption of the complaint was, which was not the same thing.
So
Isn't there a prejudice to the appellant that derives from the charge that gives the jury the question as to whether or not there's negligence on the part of Mr. Shaffer under a document that captions his name personally as the plaintiff in the case?
So the case was called as the estate of Dan Shaffer, and I believe we addressed this in our brief, that it was made clear to the jury throughout that he was suing on behalf of the estate. He was the administrator of the estate, also the guardian, had the dual role. I don't believe there's any prejudice in the caption. The jury simply did not reach this issue. I don't believe that there's any prejudice here.
But
And
the
the
fir- Go ahead.
And the jury was charged that they are not to consider that issue until they have decided the negligence question.
Correct, which they decided in favor of the defense.
And this wasn't really spoken about much in the briefs at all, but I mean, we can assume the jury came to its verdict by finding that Northeast Kingdom wasn't responsible for the actual medical issues associated with their participation in his case?
Yes. So the way the jury was charged was, were they negligent in the oversight of his case management, not his
Right.
medical care?
Right.
Because they did not have that duty. And that was explained throughout the trial. And the charge went to the jury on that basis. And so that was the question that they answered on the jury verdict.
So it was almost a legal determination using the charge from the court that that Northeast Kingdom had no duty to discover essentially, these medical records and make decisions about them?
So Northeast Kingdom's duty is derived by statute as a designated agency. And Teresa Wood and other witnesses explained this. And part of the presentation to the jury was to clarify and show the jury that this duty is derived from statute. The money flows from the Medicaid waiver. Their duty is to administer case management services, not to provide oversight of medical care.
So with whether Mr. Shaffer was negligent or not really doesn't affect that decision.
It does not, because the jury never reached it.
Was there some confusion on like when the preliminary instructions were done about confusing Mr. Shaffer's role as either an individual or as the administrator or a representative of the estate?
I'm not sure that was briefed, but the one.
It's in the one of the printed cases.
Right. So I'm sorry, the exact question was.
Well, the question was whether or not there's some confusion as to what Mr. Shaffer's role was in the case. Was it as a party directly, or was it as a representative of the estate?
I don't believe there was any confusion. I mean, I think it was made clear that he was the party, the administrator, and the guardian.
But he was not a party.
So he's the case was captioned Dan Shaffer as administrator of the estate of Jared Shaffer.
Representative of the estate.
Representative administrator of the estate. So I'm not sure that there was any confusion on the part of the jury, because the jury never even got to the issue of comparative fault. So really the question was Northeast Kingdom negligent? And they answered the question in the negative. So I'm not sure that there's much of a distinction there to be made. I'm going to move on in my argument, if that's okay. I think I would like to address the issue with Michael Montgomery. So Michael Montgomery was called as a fact witness by appellant's attorney as the first fact witness in the case. Michael Montgomery had been the 36th designee, actually originally when the case was in federal court, and testified as a 36th witness there. And when he was called to the stand, he was presented with a document that he had not seen, did not know anything about, and the same question was presented to him at his 30B6 deposition. Appellant was aware of the fact that he did not have familiarity with this document before he called him to the stand. I think what appellant is confusing here is that Michael Montgomery is called as a fact witness at trial. It's not a 30B6 deposition. If there was an issue with whether or not Michael Montgomery had knowledge of that document or should have been able to testify as the designee for the organization, that could and should have been addressed in pretrial motion practice. That was a discovery issue, not an issue for trial. Plaintiff was free to call, or appellant was free to call any witness that may have had familiarity with that document to get it into evidence, and did not do that. So I don't see an error there. The same thing with the audit, which was a document that was presented to him he had not seen. There was extensive colloquy at the bench about this, but they could not lay the factual predicate for that document to come into evidence. And finally, I think that what appellant is really arguing sort of today in the last part of the brief in chief, the principal brief, as well as the reply brief, is that he does not agree with the verdicts and believes that no reasonable jury could have found, based on the evidence, that Northeast Kingdom was not negligent. Well, the facts that were established at trial provided the basis for that verdict. That appellee, Northeast Kingdom, was not Jared's medical provider, that we were not his residential service provider, and that he, as guardian, had a legal duty to care for him. We had presented an expert witness, and by the way, he's referring to demonstrative slides that were shown to the jury. That's why they're not in evidence. And the expert witness presented testimony on this very same issue. So we're not here to do a de novo review of the jury verdict. He doesn't present any evidence of legal error on these points. And we believe that for all those reasons, the verdict should stand.
Was there any evidence whatsoever regarding the deceased comparative fault? When that the deceased had any comparative fault?
No, the deceased was incompetent.
So that's a non-issue.
Correct.
All right.
Thank you, Your Honors.
Thank you. How much time does the appellant have, please?
Appellant has 5 minutes and 2 seconds remaining.
Mr. Shaffer?
Thank you. Okay, first of all, Michael Montgomery was a 30B6 witness. Even in the federal case, even in this case, because my attorney said to him on the stand when he started, and it's in the record, and said, these are the things that, are you prepared to talk about? And he said, yes. And that was regulations. He was there as the 30B. I don't know why he's twisting it again. He's doing the same thing. The second thing is that the jury was confused. The jury was confused. And I say this again, I became the defendant. I became the person that they were targeting. The jury was looking at me like I was wrong. My son died because of me. And that just doesn't make sense. And that brings me full circle as to if you do grant this appeal, I would like this appeal being taken out of that jurisdiction and down to a lower county where I can get a fair trial, and I prefer a judge instead of a jury. I don't think the jury understands. This is a very complex case. It's a death case. This is not a real estate issue, an inheritance issue. This is about somebody who died because somebody didn't do their job. And it's very, very clear. And the jury should have seen that. This is not a colorful picture. It's black and white. And any of you, if you've lost a child, who are you going to blame? The people that take care of them. And the point of this court and the judge's ruling on comparative negligence now opens up every guardian in America has a liability now that if somebody they're taking care of and they referred them to services, professional services, and something happens to that person medically, that they're at fault because they should have gotten the medical records and read them. That means that that heirs or spouses or brothers and sisters can sue the person who was the guardian. It's unheard of that they allowed this to happen in court. I was not on trial. My son, Jared Shaffer, was going after Northeast Kingdom Services because he had testicular cancer, masses, and they didn't say it because they never got the records. And it finally was admitted by Teresa Wood when she finally said, yes, Jared's file was incomplete. And they also doctored, and I mentioned this in my brief, and I've been through this before, some of those documents that were submitted to court by this attorney don't look valid. I know Jared's signature. I know from 2012 all the way to 2017, and they don't match. And there are dates that don't match. One documents, because they were so worried, goes to the medical center in Hardwick. We want his records back from 1991. That's when he was born. He wasn't here until 2010. Something is just not right. And I really feel it in my bones. And, I know my son died. I know he had testicular cancer, but we had him at a very good place. And we thought that Northeast Kingdom would do their job. And they didn't. They met all the criteria of being negligent to my son. So I'm begging this court to really review how this judge ruled against me and my son with the layperson issues. Just calling him a layperson when he was a corporate directed person to be on trial, to know the rules and regulations of Northeast Kingdom Human Services. And that master agreement, that's the key, because it says that you must oversee the services and other providers. They changed it to collaborate. It's not. Oversee is in that master grant agreement. And they didn't follow it, and they claimed they didn't know it. Well, if they didn't know it, and they never read it, then they're negligent. Just like if I was to do something in my business, I'm negligent if I didn't know the regulation and I messed up. And that's why they have $10 million of liability insurance. Because if they do something wrong, like I have liability insurance for my business, that's what it's there for. But this insurance company is fighting me. They're fighting me tooth and nail for this organization in a town in St. Johnsbury, one of the 5th largest producers, because they're trying to save face? Come on, this is ridiculous. I have a dead child. I got a guy who's admitted he didn't do his job. I got Teresa Woods who finally cracked and said, yes, this file was incomplete. And everybody's blaming me for comparative negligence, and I'm not even the one suing. That's my case, Your Honors, and I really appreciate you hearing the way I feel.
Thank you very much. Please call a conclusion of the hearing.
That concludes today's hearings.